Humphrey said the firing of Humphreys was wrong. Did it order the president to reinstate Humphreys into his office against the president's will? It did not, for a number of reasons. One is Humphreys was dead. So what did Humphreys win? Well, zombie Humphreys was not put back in office, obviously. Humphreys' estate got money. The Supreme Court did not order anybody be reinstated in office against the Article 2 executive officer's will. The remedy being compelled by Judge Jamaica Chutkan and this 2 Obama judge majority on the Court of Appeals, that remedy was not ordered by Humphreys. So Humphreys is not precedent for that remedy. And we're supposed to believe that 2 federal judges are incapable of understanding the patent distinction here between harm and remedy. This is something that if a first-year law student could not comprehend when they were briefing these cases in constitutional law, the Duke of Wellington said about his victory at Waterloo, he said, the French came at us in the same old way, and we defeated them in the same old way. And once again, we have a federal court judge spewing utter legal nonsense in their desperate efforts to delay the ongoing victories of the great and powerful President Donald J. Trump. In every one of these independent agency firing cases, the obstructionist federal courts have ordered Trump to rehire the executive branch officer he just fired. And in every case on appeal, the higher courts, either the Court of Appeals or the Supreme Court itself, tosses out the orders of those unelected black-robed tyrannical inferior district trial court judges and says, nope, Trump has the constitutional authority to fire Article 2 executive officers at his whim. In fact, several of those cases that have made it up to the Supreme Court contribute to Trump's 17-0 record before the Supreme Court against these feckless judges. Now, when it comes to these firing cases, the most common and very weak read upon which these feckless federal judges base their orders for Trump to rehire fired executives is the 1935 decision of Humphrey's Executor. Poor guy. Met his demise before his case got to the U.S. Supreme Court. That's why it's Humphrey's Executor. It was the executor of his estate. And time again, the federal courts roll out the corpse of Humphreys to justify their ordering our Article 2 executive branch president to rehire fired executives. And time again, the corpse of Humphreys and Weiner are simply not up to the task. And I expect they won't be up to the task this time either. That is my expectation. But we're going to break down the case. The case is a Court of Appeals decision. It has a dissent, and the dissent is what we'll mostly focus on because it has the right argument, as we will see. I'll be using my red pen. Indeed, Rebecca Slaughter, her career is about to get slaughtered. Her career in federal government. This is a Court of Appeals decision, a firing case, as we've seen so many of these firing cases, in front of Millett, Pillard, and Rao. 3-judge panel for the D.C. Circuit, and Rao is the Trump judge. The other 2 are Obama judges. No surprise, 2-1 decision against Trump here, but I don't think this will be sustained on appeal to the Supreme Court, given the Supreme Court's continuous support of Trump in other firing cases leading up to this, other firing cases in which the people fired and the courts defending them have made the same Humphreys Weiner argument over and over and have lost over and over. What was it the Duke of Wellington said about his victory at Waterloo? He said, the French came at us in the same old way and we defeated them in the same old way. Well, that's what SCOTUS and Trump have been doing to the unelected black-robed inferior district trial court judges in these firing cases. All right, so let's get to this decision. President Trump fired Federal Trade Commissioner Rebecca Slaughter without cause. This is in contrast to Trump's recent firing of Lisa Cook from the Federal Reserve Board of Governors, where he provided cause that she's engaged in mortgage fraud. But for all these other firings, that's the first time Trump bothered to provide cause when he was talking about Gwynne Wilcox, Kathy Harris, Hampton Dellinger of the Country Club Dellingers, all these people he's fired. He just told them to go screw. He didn't provide any cause. And technically, their job descriptions say they have employment protections, that the Trump, whoever's president, can only fire them for cause. And Trump has said, F you, go home. Go home. Don't let the door hit you on the way out. We're not giving any cause. Your services are no longer needed. And that's how he fired Rebecca Slaughter, head of the Federal Trade Commission. He fired her without cause, gave no reason at all. By the way, Humphrey was also the head of the Federal Trade Commission and got fired by Woodrow Wilson. And so it's ironically enough, this happens to be the same job, but there's been plenty of firing cases of these so-called independent agencies and other agencies that have been upheld by the Supreme Court. So the Federal Trade Commission, there are dozens of these monstrosities. The Federal Reserve is one, of course, that's the worst. The Federal Trade Commission is another. Hampton Dellinger of the Country Club Dellingers, his office of special counsel was another. These monstrosities created by Congress, nominally functioning under Article 2, but then Congress says they're not answerable to Article 2. The president cannot fire them unless he fires them consistent with limitations imposed by Congress. That's not how Article 2 works. The U.S. Constitution says the entirety of the executive authority of our federal government is placed in a single individual, a president, the Article 2 executive branch, CEO of America. Congress doesn't have the authority to limit his powers. That would be a violation of the separation of powers doctrine. The president has core and plenary executive authority within that Article 2 function. And because all of the executive authority under our Constitution is placed in the single individual that America as a whole elects to be our Article 2 president, the only way anybody can assert executive authority is to have that authority delegated willingly by the president of the United States. Of course, the president doesn't do all the things in the executive branch. He delegates authority to subordinates. And that's really the key question in all these cases. Can he be compelled to delegate his executive authority that the Constitution places solely within him? Can an unelected, black-robed, tyrannical, inferior federal district trial court judge force the Article 2 executive branch president to delegate his authority against his will? That is the core issue in these cases. I only got one sentence in, and I already went on a rant. All right, President Trump fired Rebecca Slaughter without cause from the Federal Trade Commission, and the unelected black-robed, tyrannical, inferior district trial court judge ordered her reinstated. By the way, I believe the judge was Judge Chutkan. Anybody want to guess if Judge Chutkan was even born in America? This federal judge with a lifetime appointment in the District of Columbia. The same judge, by the way, who presided over the illegitimate prosecution of our president by Jack Smith. Remember that creep? Until the Supreme Court finally ordered her to throw the case out. That Chutkan ordered Rebecca Slaughter reinstated. In other words, this unelected, black-robed, tyrannical, inferior federal district trial court judge born in Jamaica claimed for herself the authority to order about our Article 2 executive branch president as if he were a clerk in her court. Trump naturally finds that objectionable. So now he seeks a stay of that decision, a freezing of that decision pending appeal. And this court says on a 2-1 vote, this 3-judge panel court of appeal says that motion must be denied. They say the government has no likelihood of success on appeal, given controlling and directly on point Supreme Court precedent, specifically 90 years ago. See where we're going? A unanimous Supreme Court upheld the constitutionality of the Federal Trade Commissions Act for cause removal protection of commissioners. See Humphrey's Executor. There it is, folks. Humphrey's Executor has erected itself again. The corpse, the zombie. The majority says over the ensuing decades, the Supreme Court has repeatedly and expressly left Humphrey's Executor in place and so precluded presidents from removing commissioners at will. Then just 4 months ago, the Supreme Court stated that adherence to precedent like Humphrey's controls in resolving stay motions. So this is a lie that the Supreme Court has allowed Humphreys to preclude presidents from removing commissioners at will. The Supreme Court has actually allowed all of these independent agency heads that have been fired by presidents to remain fired. Because there's two questions here. One is, was a termination unwrongful? That's the harm. And under Humphrey's executor, the Supreme Court has said repeatedly, yes, this termination, that termination of the head of an independent agency, that was unlawful. But that's only the first half of the question. The second half of the question is, well, what's the remedy for the harm? Right? If you get pulled over for speeding, the cop doesn't set your car on fire so you don't do it again in that vehicle. There's no question that you were speeding. You're not contesting that. You were driving a little too fast that day. So that's the harm. But what's the remedy is a separate question. You get a summons or you get a warning. So there's a distinction between what's the harm, is that determined to have taken place? And the Supreme Court has often said, yes, the president broke the law here, on the one hand, and what's the appropriate remedy on the other hand? As we'll see, while the Supreme Court has frequently said the harm occurred, the firing was wrongful, the Supreme Court has not said the appropriate remedy is to compel the president to rehire that person, to delegate his executive authority against his will. Not in Humphrey's, not in Humphrey's-Wiener. This majority says to grant a stay would be to defy the Supreme Court's decisions that bind our judgments. That would not do. This is kind of a retard take on this whole question. The majority here is pretending that they're incapable of recognizing this distinction between the harm and the remedy, even though it exists in every one of these Supreme Court cases, including Humphrey's-Wiener. They just refuse to acknowledge there's any distinction. So the question here in their minds is quite correctly, is Trump likely to win on the merits? That's one of the conditions you need to get to have a stay. And the second of the conditions is, will there be irreparable harm? Now, in terms of getting the injunction in the first place, Rebecca Slaughter, had to make, in theory, a similar showing to Judge Chutkan, the Jamaican-born federal judge ordering about our president. Rebecca Slaughter, or I should say Judge Chutkan, had to find that Rebecca Slaughter was likely to win on the merits. It was likely, given the law as we know it, as it exists today, that the Supreme Court would agree that she would be given her job back against Trump's will. As we'll see, that's simply not true. The Supreme Court has never done that, including in multiple firing cases just this year. So that's obviously wrong, that Rebecca Slaughter is likely to win on the merits. And then the question is, has she suffered irreparable harm? Well, you never suffer irreparable harm in a firing case, because whatever your injury in being fired, it can always be made up for by money. And this is especially true if you're an officer of the United States, like Rebecca Slaughter is, because nobody has a personal, individual property right to that job. The job's not yours. You don't own it. It's temporarily gifted to you. You don't have a right to it. So you can't have irreparable injury by being stripped of something you don't have a right to. And even if she had a claim, at most the claim would be monetary. And monetary damages are never irreparable because they can be made up for with, you guessed it, money. So this is obviously bullshit, that Rebecca Slaughter could have suffered irreparable injury by being fired. But having Chutkan, the Jamaican-born federal judge, as if we don't have enough Americans, natural-born American citizens, to be federal judges, apparently we have to import them from Jamaica. This Jamaican-born federal judge insanely concluded, despite all the Supreme Court precedent that has never reinstated a fired officer, that Rebecca Slaughter's likely to be reinstated by the Supreme Court, should it get there. And that her being fired is irreparable injury. This is literally the coming to of insane legal conclusions. But not only did the unelected black-robed tyrannical inferior federal district trial court judge born in Jamaica, Chutkan, come to this insane conclusion, this Court of Appeals, the two Obama judges in the majority, agree with that conclusion. And also the inverse. They find that now that Trump is looking to stay that order, that Trump's not likely to win, that SCOTUS would compel him to rehire this official, and that Trump, as the executive officer of the United States, he's not suffering any irreparable injury. Folks, if you are denied your First Amendment right to free speech for even an instant, every federal court characterizes that as irreparable injury that cannot be made up for with money. That's how much value and importance the federal courts place on your freedom of speech being infringed for even a moment. The same is true of the Article 2 executive branch president whose powers are unjustly, illegally infringed upon by another branch of government, whether Congress or the courts. An instant of violation of the separation of powers doctrine commits irreparable injury, because how do you make up for that with money? It's impossible, obviously. So by definition, if Trump's likely to win, the infringement on his Article 2 executive powers is the very definition of an irreparable injury that cannot be made up for with money. All right. The government, according to this majority, is not likely to succeed on appeal because any ruling in its favor would have to defy binding, on point, and repeatedly preserved Supreme Court precedent. Bucking such precedent is not within this court's description. Of course, what they're doing is grotesquely mischaracterizing the relevant preserved Supreme Court precedent. More than 100 years ago, Congress established a Federal Trade Commission. It's led by a group of 5 commissioners. They serve 7-year terms. A duly appointed commissioner may be removed by the president only for inefficiency, neglect of duty, or malfeasance in office. These are the cause. And of course, Trump has not cited any cause in the firing of Rebecca Slaughter or any other independent agency official he's fired so far, with the exception of the recently fired Lisa Cook on the Federal Reserve Board. The key substantive question presented by the government's appeal is whether the statute providing the commissioners for-cause removal protection unconstitutionally infringes on his Article 2 power. This majority says the government's highly unlikely to succeed on appeal because that exact question was already asked and unanimously answered by the Supreme Court adversely to Trump's position 90 years ago in Humphrey's Executor. Since then, the Supreme Court has expressly refused 5 times to reconsider Humphrey's Executor, including as recently as 2021. And then they cite, for example, the Weiner decision from 1958. I'm not going to go through all of these because they all have the same fundamental principle. I'm going to focus here just on Humphrey's Weiner. Humphrey's Weiner. Humphrey's Executor, this majority says, controls this case and binds this court. At least their misreading of it does. And recent developments on the Supreme Court's emergency docket do not permit this court to do the Supreme Court's job of reconsidering that precedent. By default, Article 2 vests the president with the authority to remove executive officers, but that power is not unlimited. That power is not unlimited. In Humphrey's Executor, the Supreme Court unanimously held that the Federal Trade Commission Act does not violate Article 2 by limiting the president's ability to remove commissioners except for cause. So this is the harm part of the harm remedy question. Humphrey's Executor does says if the president fires in violation of the for-cause employment protections, that's wrong. And those protections do not violate his Article 2 authority. I think that's bad law. But that's what Humphrey Executor says. If Congress created for-cause employment protections for independent agency heads and a president violates outside of those causes, he's broken the law. That's not within his Article 2 authority. Again, I think that's mistaken, but let's presume for purposes of this discussion that that's correct. The Supreme Court concluded that no removal can be made of a commissioner except for one of the causes named in the statute. In the intervening decades, the Supreme Court has not overruled Humphrey's Executor. In fact, it has preserved Humphrey's Executor at every turn. And now we get to Humphrey's Weiner. In Weiner, the court expressly relied on the philosophy and explicit language of Humphrey's Executor to unanimously uphold for-cause removal protection for members of the War Claims Commission. So Weiner had been a member of the War Claims Commission in World War II, and in 1958, he was fired without cause by the president, then in office. And he sued. Now, what's the key to Humphreys and Weiner? And all these other cases like Morrison, all the other ones they cite all have the same defect. In both Humphreys and Weiner and these other cases, the president fired without cause the head of an independent agency, and the Supreme Court said that's wrong. We are going to say that congressional for-cause employment conditions do not infringe on the president's Article 2 executive authority. Now, I think that's wrong. I think that's bad law. But let's assume that's good law. The Supreme Court said you can't fire for no cause. Did the Supreme Court, that's the harm part of harm remedy. What was the remedy? What was the remedy that the Supreme Court allowed for in every one of these cases? What's the remedy this Court of Appeals just ordered? What's the remedy that the unelected black-robed, feckless, tyrannical, inferior federal district trial court judge Chutkan, born in Jamaica, what did she order as the remedy? She ordered that President Trump be compelled to delegate his Article 2 executive authority against his will. That's what Chutkan ordered for Rebecca Slaughter. That's what this Court of Appeals majority is ordering Trump to do. Did Humphreys do that? Humphreys said the firing of Humphreys was wrong. Did it order the president to reinstate Humphreys into his office against the president's will? It did not, for a number of reasons. One is Humphreys was dead by the time the case got to the Supreme Court. That's why the case is Humphrey's executor. It was the executor of Humphrey's estate that took up the case when it got to the Supreme Court. So what did Humphreys win? Well, zombie Humphreys was not put back in office, obviously. Humphrey's estate got money. He got back pay. The Supreme Court did not order anybody be reinstated in office against the Article 2 executive officer's will in Humphreys. So that's not the holding of Humphreys. The holding of Humphreys is someone can be wrongfully fired. That's the harm. And the remedy is money. The remedy is not a forced delegation of executive authority against the president's will. That's not what Humphreys holds for. The remedy being compelled by Judge Jamaica Chutkan and this 2 Obama judge majority on the Court of Appeals, that remedy was not ordered by Humphreys. So Humphreys is not precedent for that remedy. Under Humphreys, the most Rebecca Slaughter here could ask for would be money. What about Weiner? Weiner was fired without cause from the War Claims Commission. It got to the Supreme Court. The Supreme Court said, yep, that's wrong. We're going to rule that's wrong. That's the harm. The same harm is in Humphreys. The Supreme Court said, we're not comfortable with the president firing people without cause if Congress put in for-cause employment protections. But what was the remedy in Weiner? Weiner, unlike Humphreys, was not dead when this got to the Supreme Court. Weiner was still alive. So the Supreme Court could, in theory, have ordered that president to put Weiner back in office, to delegate his executive authority, his Article 2 executive branch authority against his will. Did the Supreme Court in Weiner order Weiner reinstated into office? The answer is no. What Weiner got was money. He did not get a compelled delegation of executive authority. So Weiner does not hold for this remedy. And we're supposed to believe that 2 federal judges are incapable of understanding the patent distinction here between harm and remedy. This is something that if a first-year law student could not comprehend when they were briefing these cases in constitutional law, I tell them they got to find another profession. There's a McDonald's right down the street. They'll give you an apron and everything. So this is really the only part of the majority opinion I'm going to cover, because everything else is premised on this. Everything else, the majority writes, is premised on the falsehood that Humphrey's executor, that Weiner, that all the related cases, that they hold for the principle that the president can be compelled to delegate executive authority against his will. Not one of those cases does that. Not one of them. They mistakenly hold the president can be wrong in firing an agency head, but the remedy is limited to money, not to a forced delegation of executive authority.